Enough time on this bench teaches you that some cases do not arrive looking like they contain anything serious. They come wrapped in paperwork so routine that if you blink, you miss the human damage concealed underneath. A parking citation, a municipal code matter, a small administrative dispute that should have been resolved in one sensible conversation before anyone needed to schedule anything. And then a child walks in. That is when the disguise falls away entirely. The morning Emily Turner entered my courtroom, the room was already carrying the kind of quiet that signals people can feel something is wrong before they have the words to identify it. Emily was 14 years old. 14. She sat at the plaintiff's table with both hands pressed tightly in her lap, shoulders curled inward. The posture of a child who has spent too many weeks apologizing for something she never did. Beside her sat her mother, Sarah Turner, a woman whose face carried the unmistakable imprint of working exhaustion. Not theatrical distress, not courtroom performance, real fatigue. The kind that settles permanently behind the eyes of women living on schedules too full, paychecks too thin, and sleep too brief to absorb one more unnecessary blow. Across from them sat Officer Daniel Price. If you had looked only once and too quickly, you might have read his posture as confidence. Arms crossed, back broad against the chair, expression contained. But when you have done this work as long as I have, you learn to distinguish between confidence and contempt. Confidence answers questions. Contempt waits for questions to finish. He carried the second quality. He looked at Sarah and Emily the way some people look at paperwork at the end of a long day. Something inconvenient that should have been processed quietly and removed from view. I asked the clerk to call the matter. Petition involving improper citation, escalated fees, and related harassment. Sarah Turner versus Officer Daniel Price. Let me be direct about something. Judges are not supposed to enter hearings already angry. We enter attentive, we enter alert when the facts warrant it, but not angry. Anger interferes with listening. What sharpened me that morning was not an emotion. It was the sight of a 14-year-old girl sitting in a courtroom over a parking ticket she could not legally have caused because she was not legally permitted to drive. If that sentence sounds absurd, it should. Absurdity is frequently the first signal that laziness and authority have joined hands somewhere in the chain before the matter reached my bench. I asked Emily her name and age first because I wanted the room grounded in plain truth before anyone retreated behind procedure. Emily Turner, 14 years old. Then I asked her one straightforward question. Were you driving the car? No, ma'am. Were you in the driver's seat? No, ma'am. The passenger seat? No. Was the car running? No. Were you alone? Yes. My mom told me to lock the doors and wait. That should have concluded the matter. That should have been sufficient to expose the absurdity of everything that followed. But bureaucracy has a remarkable capacity for surviving on momentum long after common sense has ceased to function. Sarah testified next. She worked mornings and added evening shifts when available. On the evening in question, she had stopped at a grocery store after a long day because the house needed milk and she needed headache medicine. The lot was crowded, the weather unpleasant, and Emily was tired. Sarah told her to stay in the car, lock the doors, and wait. It was a decision that millions of parents make in 7 ordinary minutes without imagining that the law might be positioned outside to transform that choice into a crisis. 7 minutes. That was all. When Sarah returned, Emily was crying. A ticket was beneath the wiper blade, and Officer Price was already walking away. Emily had lowered the window only enough to ask what the paper said. According to Sarah, and then according to Emily, he told the child the vehicle was standing illegally, and the driver had refused to move it when instructed. The driver. That word kept returning throughout the case like something left in the room that everyone could smell, but no one wanted to name first. I asked Sarah what happened in the weeks after. At first, she believed correction would be simple. She called, explained that her daughter was 14, that the car was not running, that she had stepped inside for only a few minutes, that the sign itself was partially obscured and difficult to read from the angle where she had stopped. She expected someone within that system to hear the full account and produce the obvious conclusion. This should not have happened. Instead, the opposite occurred. The ticket remained. Late fees were added, then administrative charges. Because Sarah could not pay the total immediately without sacrificing something else her family required, the amount continued to grow. One officer's failure of judgment had become a month-long drain running directly into a household already operating at its limit. That was when I asked the question that matters most in low-dollar cases. Not what did the paper cost, what did it actually cost you? Sarah took a breath and told me the original amount was painful but survivable if she made adjustments elsewhere. The added fees were not. She fell behind, and an overdraft arrived when one payment cleared earlier than expected. Groceries were reduced. Bills were shuffled in order of urgency. Emily overheard every conversation, every strained exchange across the kitchen table, every exhausted sound after the mail arrived. The child began apologizing for all of it. She stopped drawing. She stopped sleeping well. She began saying she had ruined everything. That is what a single act of poor public judgment does when it lands on a private family already close to the edge. People speak about tickets as though they are pieces of paper. They are never only paper to a household balancing on a thin margin. They are stress delivered through the mail. They alter the atmosphere of every room. Then I turned to Officer Price. He told me he had followed protocol. That phrase has insulated more foolishness in this country than nearly any other. Protocol, as though the existence of a form excuses the departure of a brain. I asked him to explain precisely what he believed he was doing when he wrote a citation identifying a 14-year-old passenger as the responsible driver of a parked, unoccupied vehicle. He said the vehicle was in a no-standing zone and had not been moved. I asked whether he understood that a 14-year-old child could not lawfully move the car, even if she had wanted to. He said the code did not reference age. That was the moment I understood the issue was not confusion. It was indifference. So I opened the file my staff had prepared, because by the time this case arrived before me, it was no longer simply Sarah's account against an officer's. My researchers had examined what an overburdened working mother cannot be expected to investigate between jobs and dinner and laundry. Citation patterns, complaint histories, body camera records, municipal code cross-references. What they found was not an isolated error. It was a pattern. Over the preceding months, Officer Price had issued multiple citations in that same high-yield curb zone under circumstances that raised serious concerns. A disabled woman unloading groceries while displaying a placard he later claimed not to have seen. A delivery driver cited while collapsing from heat exhaustion. A pregnant woman ticketed after pulling over because she had become dizzy and was subsequently transported to a hospital. In each instance, documentation existed. In each instance, explanations followed. In each instance, the same defense appeared. Procedure, volume, efficiency. The language of a person who has stopped seeing people and begun seeing quota opportunities. And in Emily Turner's case, the pattern developed into something worse, not merely indifference, cowardice. Because children make easy targets when they have been taught to comply with authority, even when authority is wrong. I asked Officer Price whether he wished to reconsider his characterization of himself as simply following policy. He did not. People of his disposition often cannot perceive the ground giving way until it already has. So I laid out the evidence one element at a time. First, the citation itself, which identified a non-driving child as the party who refused to move the vehicle. Second, the municipal language showing discretionary authority available to any officer exercising basic judgment. Third, sign photographs, raising genuine visibility concerns from the position where the vehicle had stopped. Fourth, the complaint history revealing a consistent tendency to enforce against distracted, isolated, and vulnerable individuals unlikely to mount immediate resistance. Then I asked him the only question that mattered. Had he actually approached Emily as a child who might require adult assistance? Or had he approached her exclusively as a source for a citation? He gave no substantive answer. There was none to give. By that point, the courtroom understood what I understood. This was not a parking matter. It was a question of judgment. Specifically, the complete absence of it in the one person on that curb who had been entrusted with public authority. I turned back to Emily then, because while adults argue about procedure, children absorb blame. That is almost always the concealed emergency in cases of this kind. I asked her whether she believed any portion of this was her fault. She nodded before catching herself, and that movement broke my heart more clearly than tears could have. Children in genuine distress often cry. Children who have quietly internalized false responsibility do something more difficult to witness. They apologize with their bodies before they speak a single word. Emily had been doing that for weeks. So I told her plainly, in front of everyone present, that she had done nothing wrong, not one thing. She sat where her mother told her to sit. She obeyed. She waited. She did not cause the ticket. She did not cause the fees. She did not cause the fear that had taken residence in that house. Every piece of that belonged to the adults who had failed around her. The room changed when I said that. Sarah cried, not loudly, the kind of crying that arrives when truth finally occupies the space where panic has been sitting. Emily cried too, but differently. Relief on a child's face after weeks of misplaced guilt looks almost painful because the weight that releases was never hers to carry. Then I issued the ruling. The citation was void. Every fee attached to it was void. Every collection action, processing charge, and administrative consequence produced by that citation was void. I directed the clerk to clear the record entirely. Then I issued the second component of the ruling, the part that extended beyond one family. I ordered the complete file, including the complaint history and my findings from the hearing, referred to Internal Affairs and Departmental Command Review for examination of Officer Price's enforcement pattern. Because a badge is not a license to select easy targets, and public order is not preserved by treating the vulnerable as convenient paperwork. In many courtrooms, that would have been sufficient. But sufficient is not always what justice requires. Sometimes justice requires naming the moral center of the wrongdoing plainly so that no one in the room departs pretending the problem was merely technical. So I said what needed to be said. Authority without common sense is dangerous. Authority without compassion is worse. An authority directed against a child because the adult holding it cannot be troubled to think is contemptible. Officer Price looked reduced after that, though he had not physically moved much. That happens occasionally when a person realizes their posture is no longer doing the work they expected from it. The room had stopped extending the visual authority he carried when he walked in. That is one of the few useful capacities a courtroom retains. It can strip pretense down to conduct and leave a person standing only inside what he actually did. I do not know what the departmental process produced beyond what the formal record allowed me to observe. I know the review proceeded. I know the file was not quietly set aside. And I know that at minimum, one family, Sarah and Emily Turner, recovered their lives from a piece of paper that should never have existed. But what remained with me most was not his expression after the ruling. It was Emily's. Because here is what people who have never lived under financial pressure do not fully understand. A wrongful ticket does not enter a struggling household as an inconvenience. It enters as weather. It changes the atmosphere of every room. It changes the quality of a mother's voice when she opens a bill. It changes how a child interprets silence over dinner. It reshapes sleep, homework, breath. It teaches fear to expand sideways into everything. One officer's laziness can become a child's private shame for weeks on end. That is why public servants are required to exercise judgment rather than simply to process. The margin for thoughtlessness is very small when other people's lives are this tightly constructed. After the hearing, Sarah thanked me more times than necessary. People do that when the system has kept them frightened long enough. They direct their gratitude toward whoever interrupted it, even though the system should have functioned correctly, long before my bench became relevant. I accepted it because gratitude from someone who has been carrying too much is rarely about the judge. It is about the relief itself finally being permitted to enter the room. Emily did not say much on the way out. She looked back once, the way children do when they are deciding whether to trust what has just occurred. I have seen that look many times across many years. It contains a question no child should ever have to ask. Is it actually over? That morning, at least, the answer was yes. I thought about her that evening. Not every case follows me home. Many should not. A judge who carries every story into her private hours becomes unfit for the work quickly. But some remain. The cases involving children remain. The ones where adults confuse their irritation with authority or their efficiency with justice. The ones where the harm is small enough for the powerful to describe as minor and large enough for the powerless to feel in every corner of the week. This case was one of those. I kept returning to the language in the file. Driver refused to move vehicle. A line of text. Cold, neat, and administrative, and concealed inside it a complete moral failure. A child alone in a parked car, an adult with a badge, a moment that called for one more question, and a choice toward decency. Missed. That is why I tell people that court is rarely only about the paperwork. It is about the sentence beneath the sentence, the fact hidden inside the form, the human truth embedded within the administrative claim. If you read only the citation, this was a parking matter. If you listen to the people, it was a story about power selecting the smallest available target. No court that functions honestly should ever overlook that. People have complained for years that judges interfere too much, moralize too much, push into what should remain simple. Let them complain. Simplicity is frequently only the name given by comfortable people to someone else's suffering when they prefer not to examine how it began. This case required examination. It required stating plainly that a child is not collateral for a parking officer's carelessness. It required telling a working mother that the law had no legitimate claim to make her poor because someone in a uniform stopped thinking. And it required reminding one very certain officer that public service is not measured in the volume of citations tucked under windshield wipers. It is measured in judgment, in decency, in understanding when the law exists to protect and when you are simply using it to make your shift feel purposeful. The room that morning had stopped being a collection of strangers at some point during Emily's testimony. You can feel when a courtroom becomes briefly a single body listening through one nervous system. People who had arrived for their own unrelated matters were watching a child their daughter's age sit accused by a document she had not created. A delivery driver in the second row shook his head slowly throughout. An elderly woman in a red scarf whispered to no one in particular, "That poor baby." Even the clerk's hands slowed over the keyboard when Emily answered certain questions, because everyone in the room arrived at the same understanding at the same moment. A child should never have needed to come here to hear an adult admit what was obvious. I asked Sarah more questions than lawyers typically anticipate in parking matters because I wanted the full course of the damage entered into the record. How many times had she called before reaching anyone who could explain the fee increase? 4. How many working hours had she lost attempting to resolve it? Nearly a full shift, accounting for the municipal office visit and calls placed from the back room at work. How much sleep had Emily lost? Sarah could not provide a number, but she said Emily had begun waking in the night and going to the front window to check whether another paper was attached to the car in the morning. That image reached the room, not because it was dramatic, because it was entirely ordinary. Fear establishes its rituals quickly when adults cause children to feel hunted. Officer Price attempted to retreat into language. He said the zone was posted. He said the rule applied neutrally. He said signs do not distinguish between adults and minors. At one level, that is technically accurate, but discretion is the precise difference between law enforcement and law worship. We do not assign badges to machines. We assign them to people because people are expected to register context. A running vehicle is not equivalent to an unoccupied one. A licensed adult is not equivalent to a frightened 14-year-old. A parent making a brief stop is not equivalent to someone occupying restricted curb space indefinitely. The moment you eliminate all distinction in the name of neutrality, you have replaced judgment with convenience. I told him exactly that. He appeared offended, which occupied my interest less than it might have in earlier years. By now, I recognize a particular kind of officer, the kind who interprets challenge as disrespect because no one in their immediate professional environment has required them to defend the human logic of their decisions in plain language. It is not sufficient, I told him, to identify that a rule existed. I wanted to understand what he observed, what he asked, what he considered, and why none of it was enough to stay his hand before the citation book came out. He continued returning to the same empty language: vehicle present, restricted zone, driver unavailable. I finally interrupted him and said the driver was not unavailable. The driver did not exist. What existed was a child. The room went completely still after that. My staff had also prepared a brief municipal summary, identifying alternatives available to officers in situations involving unattended minors: welfare inquiry, temporary warning notation, escalation to a supervisor if circumstances were unclear. In other words, there were at minimum 4 possible responses before a citation became appropriate. He had selected the one that punished the family most quickly and required him to think the least. That is also a form of character. There are moments on this bench when you can observe a witness or a party recognize that the story they have been constructing about themselves is beginning to fail. It happened to him gradually. The shoulders stiffened first, then the jaw, then his eyes stopped their loose drifting and fixed on specific points, as though concentration itself might restore something credibility had abandoned. But credibility spent against a child is not easily reclaimed. I also want to say something specific about Sarah Turner because mothers like her are easily passed over in public systems. She did not arrive carrying any heroic quality. She arrived tired, worried about missing her shift, embarrassed to be in a courtroom over something this fundamentally ridiculous, and genuinely afraid that one wrong sentence might somehow make the situation worse for her daughter. That is how many decent people experience institutions, not as structures built to serve them, but as rooms where a single misstep might generate a new cost. People with power do not enter rooms with that fear. They enter assuming the room will accommodate their presence. The burden carried by those with less is often not only to be correct, but to present their correctness in a form the institution finds acceptable. Sarah accomplished that. She should never have been required to. After I ruled, I asked the clerk to hold the next matter for 1 minute before proceeding. Some judges resist pauses because pauses interrupt efficiency. I have learned that pauses preserve dignity. Emily and Sarah needed a moment to gather themselves without being moved along for administrative convenience. They stayed. Sarah cried. Emily wiped her face. The bailiff, who had remained very still throughout the hearing, brought tissues without being asked. Small decencies matter in these rooms. A courthouse is remembered not only for its significant rulings, but for the minor mercies that accompanied them. Later that week, I asked my chambers to confirm that every related fee had genuinely been removed and that no automated billing notice would regenerate from a system that had not received the message. You would be surprised how frequently clerical echoes continue reaching a family even after a judge has spoken clearly. We confirmed the account cleared, the citation vacated, and the collections notation withdrawn. I also asked that the family receive written confirmation in plain language, not bureaucratic language, ordinary language. Because people deserve correspondence, they can understand without requiring 3 additional phone calls and a considerable tolerance for institutional vocabulary. A month later, Sarah sent a brief note. Nothing elaborate, a thank you and 1 update. Emily had started drawing again. That sentence remained on my desk longer than it needed to. Started drawing again. There it was, the entire case reduced to what had always been at the center of it. A child who had briefly stopped being a child because adults in authority made her feel responsible for damage she had not caused was returning to herself. No statistical report is capable of adequately measuring that outcome. I do not share these stories because I take satisfaction in condemning public servants. Most of them work genuinely hard. Most are underpaid, overburdened, and attempting to maintain order within systems designed by people who rarely have to stand in the weather themselves. But that is precisely the reason to speak clearly when one of them forgets what the badge represents. Public service depends on trust. Trust depends on judgment. And judgment depends on the refusal to ever mistake a vulnerable person for a convenient target. If you ask me what made this case significant, it was not complexity, it was clarity. One child, one mother, one officer, one wrongful citation, one opportunity for the court to either participate in the damage or stop it. I stopped it, and that is why I still believe in this bench when it is being used properly. Not because robes carry weight, not because gavels make noise, but because every so often a frightened person arrives in this room carrying a lie some institution has attached to them, and the law, when it is functioning as it should, gets to answer back. No, that child is not the problem. No, that family will not carry this one day longer. No, a badge does not transform indifference into wisdom. That is justice without ceremony. And on that morning, justice without ceremony was exactly what Emily Turner had earned, simply by doing what her mother told her and waiting in the car.